Hello and welcome to Industry Spotlight with Creative First. Our guest today is Gowree Gokhale, independent legal counsel and advisor. Gowree, welcome to this discussion.
Thanks, Rohita. It's great talking to you.
Today's discussion is going to focus on the Digital Personal Data Protection Act. What are the key principles outlined in the Act for processing of personal data?
Most importantly, there are 4, 5 principles I'll put across. Personal data, of course, the whole point of personal data being, relating to individuals. So if you just keep the individual at the center, and then around that, there are various rights, right? So data protect the data principal rights, such as right of erasure, right of withdrawal of consent, etc. Right. So I will start with the data principal rights. Now, if you really see what as individuals, right, what are we really concerned about? I'm concerned about the safety of my data, right? So data security. I'm concerned about, what purpose is data going to be used, right? So purpose limitation. That means, whoever is the data fiduciary in Indian context, we use the word data fiduciary. International is the data controller. The person who's collecting and using my data, for what purpose is that person going to or entity going to use my data, right? So in that context, purpose limitation. I will allow my data to be used only for certain purposes as through consent mechanism, or only certain recognized purposes under law, right? Only for those principles without my consent also a data fiduciary can use my data, which is within the boundaries of the law. And we'll come to that as we go along. Then what am I concerned about? Security purpose. For how long are you going to keep my data? Can you keep it forever? Or can you, do you have to erase my data, or can I ask you to erase my data, right? So of course the right of erasure. So with that comes again the time period for which you can, keep the data. And the last principle is data minimization. Minimization is you cannot collect my data, to the large extent. What is your purpose? And for that purpose, are you, collect the minimum data that is required for that particular purpose, right? And of course, the last thing I'm concerned about, if I have any grievance, will I get redressal for that, right? So grievance redressal, the right of grievance redressal, right? So these are the basic, just consider, from a data principle perspective, these are the basic principles on which, the law is sort of established, which is, almost similar to what we see internationally. Yeah.
So, Gauri, thank you for highlighting the key principles from a consumer or from a subscriber point of view. But, what would or how would the key principles play a role for a company?
Okay. So the reason I started, with the data principle, because it always helps to understand, who is our audience and what are we sort of, so who are we protecting, right? So now we have understood that. Now let us see from a company perspective, right? Let's flip it. Number one, I have to clearly map my data as to what am I collecting, what am I processing, and for what purposes I'm processing, and till what period I'm processing, right? So that entire data mapping exercise will be the first step. Those who are going to start compliance now, because some companies would have done GDPR compliance already, but those who are going to start now, so that's the first step, data mapping, right? Then the next question is, now if I have to start from a compliance of law perspective, for the past data as well as the current data, I have to now make it consent compliant, right? So that means I have to give notice, which will explain what is the purpose for which I'm going to use it, right? What are the rights of the data principals I have to explain, and also tell them that, what are the grievance mechanism that they have. So there is a certain notice to be given. So I'll have to figure out my documentation on my website, or, any other, manner in which I'm interacting with my customer. I'll have to now do the notice and consent mechanism to sanitize my data for the past and for the future, for, ongoing for collection and ongoing processing, right? So then the next, once I've done that, I also parallelly need to figure out my internal processes. What are the processes I have to figure out? For what are the various items? Number one, when the data principal asks right? Because the data principle, as I said, has a right to figure out, for what purpose you're using my data. So if there is any question, then data, access to the data or correction of the data. So I have to set up the processes for data principle to exercise their right, correct? For asking for, say, withdrawal of consent or for erasure, etc. So I have to set up those principles, those processes. I also need to figure out the real purposes for which I'm going to use the data, correct? And then once in my system, I have to have the logs maintained to say this purpose is over, right? And therefore, because this purpose is over, there has to be a data erasure after after the time period for which I need to use that data is over, right? Just to give an example, the law requires that if you have not accessed the company, say it's a website, right, and it's a account that you've created, and you have not accessed that website for a particular duration at all, right, then that means the purpose may be over. So the law is, deeming certain period. For example, they say 3 years, right? So for a certain period, suppose we'll yet to see what the rules finally say. It's a draft currently, but they have given certain period to say if for this period a subscriber has not come to you, then the purpose is over. There are certain deeming provisions, right? Then you have to raise the data. But you also need to recognize, are there any legal requirements for me, because of which I need to still maintain that data, though the purpose is over. Right. So this internal analysis is going to be important, right? I'm just giving examples and you'll have to do multiple
On
of
that
that.
note, I want to ask you, say I'm a subscriber before the rules kicked in, before the act kicked in, right? I already have accepted terms and conditions, which is the standard
Yes.
template anyway. So will this now, with the rules coming in, and if it gets notified, do all the companies then revisit their existing subscriber base and take explicit consent again for this act?
No, so the way, interestingly, the law reads, and the rules have not given that clarity, how
Right.
it will be achieved. But they do say that if you have already taken consent, okay, even then the notice unfortunately nereeds to be given,
So
right? Of
it'll
the
have
all
to
the
be
points that I
revisited
mentioned,
more,
right? The
right?
purpose, once again, you have to explain, you have to give them, what are their rights, you have to give them the grievance redressal mechanism, all of that, right? And but they have already given consent. If with that case, you're simply giving the notice, correct? And then if they want to withdraw, they may withdraw consent, whatever it may be.
Right,
But
but
if they have, if there
consent,
is
as
no
you earlier
consent
said,
given, then you
yes,
have to give the consent. So there are these three buckets. So
got
that's
it.
why, you need to really figure out for what
Right,
consent. And your question is very valid because the earlier law did not require that for
right.
regular data, right? For sensitive personal data, it did require. But what you say, I mean, honestly, many companies may have already taken consent because that's a standard process followed, that, there is consent. The question really is the consent as required under the act. All your purposes have been specified and all of that, right? If the notice was not adequate at that point in time, because now you have to clearly articulate purpose. If your earlier notice was wishy-washy, right? So that is the due diligence one will have to carry out. All the companies will have to carry out. And of course, the last point being, as I started with, is the security of the data, right? So that's the security. The act doesn't prescribe a specific, standard of security. The proposed rules are giving certain principles that you need to follow. But there is no, like, like we have in 27001 ISO, etc. So that kind of prescription luckily doesn't exist, but they have given certain principles. Yeah.
What is the impact of the act on the media and entertainment sector? Positive, negative, challenges, everything.
I think I'll put it into three buckets. One is your regular thing, which I said just now, one more from a process perspective. Oh, now I have to set up these processes in place, consents in place, which is more procedural, right? Which is your legal and compliance teams will, maybe take a couple of months and put that in place, right? The second thing is really from a marketing and behavioral marketing perspective, right? What does it mean? Right? What type of purposes can I articulate which are within the, within the framework of the law? That will have to be examined. Within that, you have children's data. That is the biggest piece I think we need to watch out for media entertainment industry, because you have youth, when I say youth, which is actually below 18, category also, there are several segments. International use is 13 plus, for the consents and all that, right?
There's
But
preteen.
yeah, but in India it is 18 plus. Now imagine, the verifiable parental consent. That's a concept. I did not say it before because I was just waiting for this question probably. But the verifiable parental consent is going to be a big sort of procedural hassle to watch out for. And also what, the targeted advertising, there is a provision against it. There is a provision against behavioral, monitoring and things like that, right?
Could you explain targeted advertising and also behavioral? I think
Yes. So, for
need more clarity.
example, if on a particular platform you are looking at, say, which sort of which content this person, I'm just going to use the per person, right? This person is watching, right? Based on that behavior, I'm going to give you certain suggestions, which is not uncommon. And let me also give an articulation. For example, if it's though we say you're asking about media and entertainment, I will put gaming within that. Probably some edutainment as whatever they say, right? So that sort of content, right? So for all these pieces also, the law will apply, right? And then if I have to watch your behavior and then do a targeted sort of suggestions, give advertisements, right? So that is where the law says that you cannot do that. Now, there are exceptions possible, and that is where now we need to see in the rules there are already certain exceptions given, for example, health, education, and things like that. But for media, there is no such call out exception, right? So that means if there is no exception, then that's something we need to really I would say that this is the time we need to call it out and explain. I'll give you an example, right? When you say that don't do targeted advertising, my question very practical comes to my mind, that you really need to do advertising which is not harmful to the children, right? If then in that case will have to do some kind of targeted advertising, because I don't want to give content which is harmful to the children. Same thing with the content, right? So but there is another provision which says that you will not do the processing of the data which is harmful to the children. So how do you read these two provisions together, right? So I believe there will have to be clarification to say that to the extent you are doing behavioral monitoring or you're doing targeted advertising for the protection of the children, then that is okay, because two provisions will have to be read together. I'm just sort of giving my
Yes,
suggestion
but
also,
as a
right? Because
company, for
yeah,
example, I am basically putting out a documentary, or it could be a very educational program, web series for children.
correct.
How do I know whether I can target children or no?
No, no, exactly. So there is a guidance that is required. One is from the exception perspective. You give clear exceptions, that is the best case scenario for all of us, right? But currently, as I said, the exceptions are limited, right? And if there are FAQs that the ministry can come out with, right? I mean, maybe in the end we can also say what are the next steps, right? When we come to that, we'll
Right.
deal with this. But if there is that clarity provided, that is going to be important, right? So coming back to your original question, so one is the internal processes. The second piece is part of that is, how are you going to manage the verifiable consent from the parent? And there are several steps that the government has suggested, right? So that's going to be a little tedious. So that is one piece to watch out for. The third very interesting thing, now there are digital avatars and all of that being sort of created basis, your so suppose I take the rights from you to create your digital avatar,
Yes.
right?
Which could be a
And for that,
character. Could be a character.
exactly, right? And you may not be like an artist or a talent or anything like that, but I just like your personality. I have taken your rights. Okay. Tomorrow, if you say, no, erase the data that you have collected from me, my photographs, because that's a personal information, right? My photographs, my videos that you have recorded, erase it, right? Now the question is, what is the purpose? Is that purpose over, right? So I would say some of these interesting questions are going to come up for the media industry when they are going to look at the talent and their recording and use of that. Interestingly, internationally, I was talking to some clients, and of course, internationally there are certain exceptions which do not exist under Indian law, unfortunately, right? For contract as an example, right? Contract being an exception, right? But internationally, there were certain interesting situations where I understand that when the GDPR came in, the people, suppose there was a shooting and people were in the background, right? They said that, that is my, like my person, like my projection appearing, right? And now erase it, right? So, those will be very weird situations for the media and entertainment industry, right? So there has to be some additional thought given as to, what are the additional exceptions required, because under the current exception, so as I said, consent is one, and as I was explaining, there are other legitimate, sort of exceptions or legitimate purposes which are recognized under law, right? For example, employees, when you are to manage their data, right? For the employment purpose, there is an exception. Similarly, if exceptions could have been given for contractual relationships, then this question would not have a reason, because contractually you have agreed to give, or rather, you have agreed to give me your persona, right, for the purpose of creation of an avatar. Then contractually we are agreeing, right? Then the question of withdrawal and all of that doesn't arise, right? So this is where I see that we need to watch out how the law develops in the Indian context from a media and entertainment industry perspective.
From what you said previously, what happens if it's a branded content? So it's a branded web series. Maybe the brand is in the education space, and it takes a lot of time for getting the consent, because obviously we're talking about children as a base here. Obviously that affects a lot of financials, right? At the end of the day, your subscriber, suddenly you may have to kind of erase those subscribers because of the consent. How do you really see this play out, and what is a possible practical solution to handle all of this? And not only just
No,
for children, but even for adult content, if it's a co-branded content, where we know that yes, there is a streaming service, an online curated content platform, but it's a branded program, and which everybody knows. How do you see this practical? What's the practical solution to this
you're talking from an artist perspective or talking from a
from a company perspective?
no, so company and artist perspective, or you're talking more from a company and
So
subscriber
the company,
perspective?
so yes, company subscriber perspective. Yeah.
Yeah. So see, basically, so the way I look at it, right, that once I have got your data, right, and that relationship is contractual, ideal situation would have been whatever contractually we agree, that is what, sort of prevails, right? But that is not how the law reads today, right? So therefore, the law is sort of interfering in our contract, I would say that. So even
Yes.
if you have told me, for example, if 3 years you, or whatever period finally it is agreed, you don't come to my platform, I have to erase it, right? Now I'm going to launch a new service, and I believe that, this service may interest you. So I could have approached you, sort of done some marketing to you, but now I have erased your data. You may lose that benefit, that because, now you're not going to get, that kind of service. When I say service, I'm saying that suggestion for the service, because now I don't know who you are, right? So somewhere I feel that there will be that gap of outreach, right? When there are these gaps that occur between a subscriber and a company, right? Where subscriber may have lost interest in one service, but may be interested in other service, but now you will not be connected by the service provider, right? So this is only an example, but these are the
Yes.
gaps, that are going to arise, overall. And for example, if my consent, language was not sufficient enough to say approach you for, something which may be actually beneficial to you, but I no longer can approach you because you have not signed up for that purpose, right? So that is where I see there could be some gaps between a relationship between a company and the subscribers.
Also, if you can give us a practical example again, on this children's content piece, or targeting children, how will it practically work out? I mean, a service puts out different types of content. Um, Most likely, it is the parent or the child themselves. In case, say, of friendly animated series, a child may already know, right? I want to watch this, or the parent may say, this is what you need to watch. how will the whole consent piece work? Because I mean, frankly, as a service, if I'm providing this content, I'm putting it out to a subscriber, and most probably the subscriber is the parent. It's not really the child, especially if you're talking of an, 12-year-old or 11-year-old. So how will all of this play out? And also, if you can compare this with how it's really working in the rest of the world where such laws have been implemented.
See, I think in other countries, luckily it's a 13 plus, right? And most of the time, I mean, just from a societal perspective, anyway, it's not ideal for 13 below children to sort of have that, independent access, right? So, that is where the threshold age itself is different anyway, internationally, right? And that was one of the suggestions, if you remember, the entire industry had made to make it 13 plus or maybe a 15 plus, but unfortunately, that was not accepted. Now, coming back to your question, this law doesn't require me to figure out whether you are a child or not. It depends on a declaration by the individual,
Excellent.
right? So, if you are coming to me as an adult or declared as an adult, that's about it, right?
Right.
But honestly, there are certain companies, you and I know, that there are tools available in, now, which you can deploy, where because of the behavior you can recognize whether a certain person is child or not. So it's more of a corporate ethical behavior for which you are deploying these tools, right? And identifying there is a possibility of somebody being a child, right? And luckily for that processing, the proposed rules are sort of giving an exception, because by that time you don't know, that person is a child, right? So coming to the process, so first you have to declare that yes, I'm a child. Once you declare you're a child, then the parental consent is required. Now when I say parental consent in case of a child, disabled people, of course, there are guardian and all that. So let us keep that in mind also. And there is some anxiety around that as well. In the recent consultation, there was lot of anxiety expressed in the case from an accessibility perspective. I'm slightly digressing, but that's an important conversation as well, because that today in the media and entertainment industry, accessibility also is becoming a very important point, right? That's why I thought I'll just mention it. So coming back to the children's and parent, right? So there is not even a requirement to clearly identify that the person who's declaring herself or himself as a parent in fact is a parent. Okay, the requirement and the proposed rules say that they have to verify that person is an adult, correct? So then you need to demonstrate you are an adult through, say, suppose your parent is already registered on the platform, right? So that information is available on the platform, so they will do verification as per that.
You were earlier mentioning, about parental consent for
Yes.
targeted advertising. So if a 15-year-old or a 16-year-old is accessing social media in an ethical way, and also depending on what social media platform he or she is using, he or she may receive targeted advertising, which will be relevant to that age group. So in this case, how will consent work?
No, that's an interesting question. So what we are really saying is that a parent has given consent for a 15-year-old to access the platform, right? So we are going on that basis.
So we are
And
assuming that,
now, correct,
right?
we are assuming
Yeah,
that.
yeah.
And now the platform knows that that person is a child, correct?
Right.
And that is exactly what I was saying, that when you say that there should not be targeted advertising, but at the same time there is a provision that you will not process the data which is harm for the, which is harming the children. So that means indirectly I'll have to ensure that the suggested content is not
Yes.
harmful to that child. So that means
Yes.
I'll have to anyway do, some targeted, say whether it is advertising or even some extent monitor the behavior. For example, if there is a platform which is socially conscious and they want to say that, okay, certain child, they can see, from whatever their AI deployment or otherwise, a certain child is undergoing, say, like conscious about weight or something like that, right?
Right.
And having some, like issues with the, the body, like body shaming and all that. Suppose
Yes.
that child has gone through, and the platform is really intelligent and recognizes that, they will want to avoid, they can watch that behavior and avoid showing, say, snaps or pictures or, things which are, of other people, right? Sort of which will have a mental effect on that particular person,
Right.
right?
But
Now you're really wanting to
yeah.
protect that child, right? But the way the law reads, it's little convoluted. So then the
Yes.
platform will have to justify that because I want to protect the child, I'm doing this behavior monitoring and targeted, content, right?
But my
So
question was actually making it very simple. From a very
yeah,
marketing point of view, right? I'm
yo-
watching something. I love to eat chocolates. I mean, kids love chocolates. They may
yeah,
like to have some snacks. And now, how much of that will be? How do I
that will
really
not be
determine
allowed.
where?
To put it simply, that is not going to be allowed because then
Understood.
you're not protecting the child. I mean, I went a little overboard with the child protection thought process, but that exception doesn't apply, right? So the targeted advertising is not permissible.
Right. Moving on, what is the role of the Data Protection Authority in India?
That's an extremely important question, Lohita, and I'll tell you why. And I mean, I have some anxiety around that piece. Let's go, stepwise. So currently, the data protection board's role is only adjudicator. So if there is a grievance, right, against a data fiduciary or a consent manager, right, in that situation, then only then that the board comes in, correct? That is number one, which includes a breach notification, right? So if there is a breach in my system as a data fiduciary and there is a data leakage or otherwise, and then I'm reporting to the board, right? So these are the only two purposes, and of course with that there will be investigation and maybe some penalties and things like that. But as you can see, it's more of a of an adjudicator role, right? And to some limited extent, registration of a consent manager, right? But the board is not giving, as we have seen in other countries, that the board or the authority gives the guidance to the industry by issuing rules, guidance notes, for the compliance purpose. So the board's role is not going to be rule making, regulation making, issuing clarifications. That will be done at the ministry level, which is your Ministry of Information and Technology. Imagine a ministry which is so busy, right, with so many things coming up. They are also managing semiconductors, PLI, right? That, so hardware also goes to them, right? Then you have so many issues that they're handling on the intermediary side, right, as a regulator. Then you have AI also being managed by them. So what I'm saying is there are so many things that they manage, right? So to look at MeitY to become a guidance to the industry, uh, how much can, I mean, I'm not saying they will not do it, but ideal situation could have been a board which understands the data, which understands the industry, that is equally important, various types of industries, a good representative board, and then that board is becoming a guidance as an administrator overall, which is not the case, right? So the board's role will be very limited, and we'll have to look at MeitY for other guidance.
And do you see any possible solutions around that?
I think what will
Is there
help is
enough of, probably interpretation of the act which can later on give administrative powers to the board, including enforcement and adjudicatory powers?
no, apart from enforcement, and as I said, two, three items, breach notification and enforcement, I don't see that. The possible solution I see is at this stage, whilst the act is getting implemented, if the industry, and this is the call to the, call for action, it's for the industry, various industries rather, right, to identify, because see, each industry is going to have unique issues. The issues that you pointed out for children from a media industry perspective, right? Some other education industry will have similar issues, right? So industry wise, healthcare industry has completely different issues, right? So if you really see, across the board, if the industries can work with the ministry and to come out with good FAQs, which are industry focused FAQs, if so is, if that is required, right? And we work for next 1.5, 2 years, right, to get a great guidance going, through the ministry. It will be some work, but that is the best case, in between scenario where there is guidance available, and then we are able to play with that guidance in terms of its implementation.
What is your opinion on, the data localization part of the act?
If you really see section 16, I'm just going to be a little technical here. If you really see section 16, there is no concept of data localization as we saw with the Reserve Bank of India guidelines, for their sort of financial data, right? The concept really in section 16 is that you cannot transfer the data to the country which is banned, to put it very, very simply. So they're
Right.
contemplating certain jurisdictions that the government may come up with to say that please do not send data to that country. That's about it. Right? That is what section 16 says. Rules are little somewhat weird, and I hope they get sorted out in the consultation, because what the rules are saying for the significant data fiduciaries is indirectly localization in a way, to put
Right.
it just to use that word colloquially. So they are saying for certain data, so it's going to be very weird for SDFs only, the significant data fiduciaries, as and
Right.
when they get identified, then then there is that confusion. So I hope that gets sorted out. But if you really go by the principle in the main act, there is no data localization concept as such, which is a good thing.
Right. The draft rules of the Digital Personal Data Protection Act have been published. What are your comments?
Uh, rather a lot of work is required. So my first comment is going back to my suggestion. The entire industry needs to work on it, give good suggestions. There are, in fact, certain clarifications required from the ministry. So I think the first step would be to get those clarifications. Overall, if I have to give just higher level comments at this stage, I think they have kept tried to maintain simplicity as in the case of the act, which is a good thing. They have tried not to micromanage. For example, there was anxiety that whether the manner of giving notice will be will be sort of, or rather the wording of the notice will be prescribed. The manner of giving notice, whether has to be by email or a pop-up or whatever, may be prescribed. So luckily there is no over prescription, right, which is a good thing. But there are certain gaps, as I was mentioning, say children's data consent. There is a gap in that notice for the past data, right? How it should be given, because the rules, rather the act says, the rules will prescribe. There is a gap in that, right? So there are these, sort of elements which it can be smoothened out, during the consultation, and there are several more, but because of uh, the want of time, I'm just limiting to as an example. But I think some of the gaps do exist. In fact, the biggest gap is the rules don't even mention which provision of the law they are, of the main act they are relying upon, which section they are relying upon for which the rule is getting framed, right? So there are these drafting issues that do come up, which can be resolved. So there will be some. So the way to put it up, there are certain areas where additional rules are required. There are certain areas where drafting needs to be clearer. There are certain areas where additional exemptions could be considered. For example, for Section 9 children's data, we saw,
Yes.
there could have been additional exemptions that could be given, right? Then, for example, for how much period can you retain the data, right? They have only given guidance to e-commerce companies, gaming companies, and education companies, right? They have not given guidance for other industries, right? So for how long can they keep the data? Though there is no guidance, at least some guidance could be provided, right? So
Right.
there are these gaps that exist. So I hope those get filled in the final draft.
What about any challenges with respect to consent managers that you see?
See, consent manager. Let us first discuss the concept here, right? Because for the audience,
Yes.
just from a familiarity perspective, as a user, if I have to give consent to multiple data fiduciaries, right? What the concept it started with to say that, okay, through one consent manager, right? You can manage your consent for various platforms. You don't need to figure out, with each data fiduciary, your consent. But the flaw itself is that means that consent manager is my representative as a data subject or a data principal, right? Now imagine that there are, say, 20 data fiduciaries totally. Let's just limit, from discussing the concept. The problem today is that if there are three consent managers, Okay. And out of those 20, I'm signed up with 10. Okay. But the consent managers have not onboarded those 10, they have onboarded the other 10, all the three consent managers between them. So I
Yes.
don't have a consent manager at all because the data fiduciaries are not onboarded on my the consent managers at all, the ones which I'm signed up with, right? So how the marriage will happen as to between the consent manager and data fiduciaries is something which is not clear,
And
right?
that can be
That it is
clarified,
not
you think, in
mandated.
the rules? Can it be
No, it
clarified?
is there is no clarity in the rules on that. They have what the
Right.
rules have simply stated that this is the registration process. This is your eligibility criteria, and unfortunately, the consent managers have not been given guidance for the security of the data. The
Right.
way the fiduciaries have been given guidance, there is no direct guidance. One can interpret to say, okay, maybe it is applicable to them also, but that clarity could be brought in. But the biggest hurdle is how do we really visualize it, right? In terms of so if my data fiduciary, now put it the reverse way, my data fiduciary doesn't have any, is not onboarded on any consent manager. For me, consent manager doesn't I mean has no meaning,
Right.
right? So we'll need to wait and watch. And typically eligibility criteria are pretty standard, right? So I'm not sort of making any major comments on that. But I think I'm not too sure. And the other thing they say there cannot be a conflict of interest between a consent manager and a data fiduciary. Earlier there were talks whether the play stores can become consent managers,
Right.
right? Because then at one place you're managing that. I
Right.
mean, I just sort of heard people saying that that could be easier or whatever. But the
Right.
question is, if you're saying conflict of interest, then the play stores will have arrangement with the apps in them, right?
Yes.
So then the question is, how can you say there is no conflict of interest? So it's not very clear that conflict of interest, in what context they are looking at. So I think I'm not too bullish about this entire consent manager, if you ask me. I think it will take some time for that.
Do you really think that the deadline that they have given the industry to respond is reasonable?
Um,
Because I mean,
Not
we,
really.
just from this very short conversation, and we've not got into details, and which we will possibly in the next conversation. This really requires a lot of thought, thinking, discussions, consultations, and I think this, therefore, the deadline, while there's still time, do you think it should be relooked?
So, I'm going to wear a hat now of a co-chair of FICI's Data Protection Committee, and then answer this. And definitely the timeline is not sufficient because when we were doing the last round and discussions, I have to look at multiple industries. So today we are talking only about media and entertainment in this conversation. Fintech industry has major issues. The banking industry has major issues. I would say the BFSI sector itself. The
Right.
healthcare industry has another set of issues, right? And that's a huge industry, the diagnostic. Imagine the entire chain, right?
Yes.
Then you have, the digital industry where there are multiple stakeholders on a single platform. Even from the start of who's a data fiduciary and who's a processor, that itself is so confusing, right? So when I'm looking at so many things and there is so lack of that clarity in the main act itself, and then to give comments on the rules which are so like so many with so many issues. I gave that background because I can visualize that so
Yes.
many comments are going to come my way. And
Yes.
as a co-chair, for me to collate all that, I don't think is going to be sufficient. I believe they're likely to extend by another 15 days. And the consultations are still ongoing. As you know, there is one coming up on 20th, Monday in Mumbai, luckily. So I hope they extend the timeline. They have already waited for so many months. Maybe another 15-20 days would be great.
Yes. What steps should an organization take to ensure compliance with the act?
I would say that, don't wait for the final rules. Start. Number one is data, your entire data mapping. Start identifying who in your ecosystem are the fiduciaries. For example, if there are group entities managing data, right, between themselves.
So
Who is the
let's
data?
can you give an example from a media and entertainment perspective?
Sure. For example, you have one entity which is, say, having an OTT app, right? In the same group, there is another entity which is broadcasting industry, right? Rather into broadcasting. There is a third thing which is into gaming, right? And suppose they were exchanging, their consumer data, doing some, sort of,
Absolutely.
you can sort of imagine, right, the data mapping and then doing marketing activities, or some convergence, sort of between the three entities. Now, these are three separate data fiduciaries. Can they share the data? In which case that can they share the data, right? So you will need to really do that mapping. And when you have conglomerates, it's going to be a huge job for them to figure out where the data originated, who's your first fiduciary, right? So because the data enrichments have already happened, right? So to go back and then figure it out, right? So that entire data mapping process is going to take time. I hope everybody has already started that, but if not, let's start that. So that is point number one. As I said, point number two, your internal documentation, right, with your data processors, because the liability under the act is with the data fiduciary and not the data processor.
Yes.
They will have a contractual liability between, you and the processor. So your arrangement, not only your documentation with your fiduciaries, your group companies and all that, but your documentation with your processors will have to be revisited. So this entire documentation mapping process, apart from the data mapping, and figuring out, what sort of documentation needs to be updated
And
with each
processor
of
in
them.
this context would be for
Sorry.
the audience, the processor, the data processor in this context of our industry would be whom?
Sure. So, for example, your marketing, suppose you're outsourcing marketing, right? And then you're sharing your customer data to the marketing team. And then marketing team is, having another company doing the marketing for you, right? And they may be doing the outreach, say, through advertising, right? They may be tying up with some ad platforms, right? So those are the situations, those will be your data processors. Those are not data fiduciaries. You have a relationship with your subscriber, right? Forget the subscriber data, your own employee data. You may be having an outsourced HR, software manager, right? And that management company is managing your employee data software, in an outsourcing relationship, right? So all of that will have to be understood, that who's my processor, what is the relationship I need to have with that processor in terms of protecting me, because if even if there is a breach in that processor systems, I am going to be liable. So I'll have to do the auditing of their systems from a security perspective, right? So that is where, that is the ecosystem sort of due diligence I'll need to carry out, right? Yeah. And the
Any
last
other
one,
thing that comes to your mind?
yeah.
Yes.
So, and of course, the last thing is, as I said, your internal management, right? The process is for allowing the data principal to exercise their right, including appointment of a grievance officer, right? So these are your internal processes that you will need to put in place. And of course, the last one but not the least, your insurance, because you are going to be liable to high penalties, right? Should you not comply, right? You're found to be non-compliant, there may be high penalties. So you should have a proper insurance in place to cover you as well.
And also probably a data protection consultant.
Absolutely.
Thank you so much, Gauri, for this very insightful conversation. And, I think this definitely deserves another conversation as a follow-up. But
Sure.
thank you so much for this precursor.
No, my pleasure. And as you rightly said, I think the next today was more of general sort of, like a 30,000 feet kind of a view. But probably if we speak next, we can go into the specifics of that. I've tried to
Sure.
keep it
Very
simple
useful
today
audience.
without
Yes.
referring to the provisions, sections, and wordings. But
Sure.
next one could be, more deep dive.
Thank you so much.
Okay, thank you. Bye.